Hi, today we're going to review constitutional law as it applies to drug testing, and we're going to review volunteer associations. The application of constitutional law to sport involves whether the actions violate one or more terms of the U.S. Constitution. So we're going to focus on state and local governments, state action. Purely private entities or volunteer associations that we'll look at are generally not subject to constitutional claims, and state action is the first thing that we look for. If it's state action, then we can proceed. The Fourth Amendment gives us protection against unreasonable searches and seizures, and it says the right of the people to be secure in their persons, houses, and papers and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So this is protection for the citizens against the police, against the state, against the government of unreasonably searching and seizing our property or, as it says, persons, houses, papers, and effects. So we'll look at this idea of the right to privacy. We have a right to privacy against the Fourth Amendment. There is actually no right to privacy. That privacy interests are actually found in the penumbra or in the gray areas guaranteed in the First, Fourth, Fifth, and 14th Amendments, safeguarding privacy interests relative to freedom of expression, substantive due process rights, equal protection, and the Fourth Amendment with this idea of search and seizure against one's persons and personal effects. So we guarantee that individuals are protection against arbitrary invasions by governmental officials. Remember, governmental officials, that's the first step of state action. Is this either something that the government's done, or is this something that, due to the entanglement theory, that a private institution is doing something and is connected to the public, therefore the private entity is performing state action? So the first factor that we have to look at, is there a legitimate privacy expectation on which a search would intrude? Our expectations of privacy are very different depending on where we are. If I'm in my house, I have a higher expectation of privacy than I am in my office, or if I'm outside in a public area. So where I am will influence my privacy expectations. High school athletes generally have a lower privacy expectations because schools have a custodial responsibility for the students. So by going into a school, you have a lower expectation of privacy for a high school athlete than you would at home. Also affecting privacy expectations of athletes, as we'll look at in a couple of our cases, is the fact that athletes shower and change together both before and after practices or games. Therefore, your expectation of privacy has to be smaller or diminished because you're choosing to do this activity that opens you up to other people. So we look at the expectation of privacy. We also look at the character of the intrusion. And when we think about unreasonable searches and seizures, drug testing is one of those aspects that we're looking state actor, and instead of walking into your house and looking for things, we're taking blood or we're taking urine and searching for things. So drug test really is a Fourth Amendment issue. So when we look at the character of the intrusion, a court's going to look at both how the drug test samples are collected and what type of information is being, taken from it. If you think about the intrusion, a urine test is much less intrusive than sticking a needle in your body and drawing blood. That watching somebody deliver a urine test is more intrusive than just listening to the audio sounds of somebody urinating in a cup. So we look at how it's being collected. What type of information is being collected? Are we just looking for performance-enhancing drugs? Or are we also looking for recreational drugs? Drug tests can tell us a lot of things. What about pregnancy? or Down syndrome or other types of illnesses or conditions that may be a part of a person, are we testing for them? That would be much more intrusive. The nature and immediacy of the governmental concern. The court must determine whether the state's interest in conducting the drug test is important enough to justify intruding on the individual's genuine expectation of privacy. So we're going to measure the character of the intrusion, both how it's collected and the information being collected, as well as the nature and immediacy of the governmental concern. Why does the government say it needs to drug test this group of people? The nature and immediacy of the governmental concern we'll look at. In other words, is the state's interest in collecting this information important enough to justify overruling the individual expectation of privacy? So it's a balancing test. It's a differentiation of opinion here. We're looking at the expectation of privacy on the individuals versus the nature and immediacy of the governmental concern of getting this information. Fourth Amendment requires that any search be conducted with probable cause. However, we've seen that waived because a drug test is a suspicionless search. We're going to test everyone and find out who's guilty. That's not probable cause. Probable cause is saying that this specific individual, I have reason to believe, has some sort of illicit material. Not everyone, I'm trying to find it. Supreme Court has waived the probable cause requirement when a state has shown it has a special need. When it has a special need to assume everyone may be, in this case, affiliated with drugs. When we look at the Vernonia versus Acton case, this really fleshes out this idea of student athletes being drug tested. In the Vernonia dissent, 3 justices said that a suspicionless search should be considered unreasonable and a violation of the Fourth Amendment. However, the court upheld Vernonia's school district's testing procedure by applying a balancing test. The balancing test, waiving those student privacy interests against the need for testing. That privacy interests, talking about very few activities, certainly for a student, are more private than urinating. Monitoring the event is degrading and embarrassing for the student. That the chemical analysis reveals much more than just drug use, such as pregnancy or diabetic or epilepsy. It interferes with the privacy right to control one's own medical treatment, and it regulates off-the-field conduct and thus violates a person's privacy. So what the school district is arguing, or the privacy interest of the student is saying, that you're not just saying what I can and can't do on the school grounds. I may have taken a recreational drug or PEDs off campus, and now you're testing for it. In Vernonia, students have to suit up before each practice or event and shower. Therefore, they have a reduced privacy expectation. Health examinations of student athletes before they go and participate are fairly routine. If you don't pass your health exam or have a health exam, you're not allowed to participate. And the school system of Vernonia is testing method to afford protection of the privacy interests of the students. It's searching only for specific drug use. Very few personnel saw the information. It was coded, and if it came back positive and the other test was positive, it would be shared with the principal. It's not being shared with law enforcement. Even if you test positive for some sort of recreational drug, you're not going to be arrested for it. So when we evaluate a Fourth Amendment or drug test, we need to look at 3 different sets. First is the starting point state action. Is this state action? If your school is a public school, it's state action. If you're a private school, it may be lessened. Is the conduct officially a search? Is that search reasonable? First of all, we look at, is the conduct a search? Supreme Court has said the collecting and testing of urine constitutes a search under the Fourth Amendment. Therefore, is it reasonable? You have an expectation of privacy that society is prepared to consider reasonable is infringed. So we look at, is it reasonable? We look at, is it justified in its inception, and is it justified in the scope? Was the search justified? Was there reasonable suspicion? We don't have probable cause, so we don't need it if we show a need. And is it reasonable in the scope, the degree of the intrusion against the government's testing, that balancing test that we just spoke about? So we have different types of searches. Individualized suspicion, where a warrant is required, or if you're in a school setting, warrantless if it's going to intrude on the educational interests of other students. A general search must have strong governmental interests, such as potential drug abuse in an epidemic of drug abuse in a community, I think is what Acton looked at. When we looked at Board of Ed, Pottawatomie County versus Earls, we extend Vernonia versus Acton 7 years later to not just student athletes, but any student in an extracurricular activity. Remember, in Vernonia, we can look at, when we discuss the case, that part of the reason why there was this lower expectation of privacy is athletes change before games and they're naked and they have to do a health exam. Well, in Earls, we're looking at this idea that it's not just student athletes, that we're looking at people in band, in chess club, and all these other activities. They don't have that lowered expectation of privacy that was given in the case 7 years before. Do we and are we allowed as a society or as a school district to search all expectations, all student athletes, all extracurricular activities? We'll also look at Safford versus Redding, that went even further with a strip search of a student. Is that allowed or not allowed? So when we look at the drug testing idea, we look at this idea that there has to be state action, that state actors violate this idea of unreasonable searches and seizures. However, a voluntary athletic association is a little bit different when we look at this idea of a private actor. If you are a voluntary athletic association, it's groups and individuals who voluntarily join and agree to abide by these regulations, like the NCAA, like the AAU, like the USOC, like the National Parks and Recreation. So if we're looking at this idea and you do not agree with the rules as stated within the association, if you're a part of the association, you need to follow them. If you're not, then you leave. For the most part, we're looking at this rational basis rule, where courts will allow an association to create their own rules and to follow it. A court will overrule it if the regulation exceeds the scope of the authority, if it violates someone's constitutional rights, if it violates an existing law, or if it's applied in an arbitrary or capricious manner, only where it's willful and unreasonable, without consideration and disregard of the facts or circumstances in the case, and without some basis which would lead to a reasonable and honest person to the same conclusion. So it has to be specifically arbitrary and capricious. Where the rule or regulation is fraudulent or unreasonable, or if the association breaks one of its own rules. So when we look at the idea of constitutional rights, high school athletic associations are widely accepted as state actors. However, the NCAA is not a state actor, thus limiting the constitutional rule. We look back at the Brentwood and the Tarkanian cases where we defined this type of state actor versus non-state actor. If an establishment is a place of public accommodation, then it's covered under Title II of disability law and needs to be compliant with federal legislation. Theaters, concert halls, sports arenas, and stadiums are specifically mentioned under Title II. So a volunteer association, is a group truly private? A volunteer association can be a state actor. It can be a private organization. It may have specific constitutional responsibilities. It may avoid constitutional responsibilities if it's private. U.S. versus Lansdowne in 1990 really defined this idea of what a private organization is. In Lansdowne, a court looked at and decided we're going to see 8 different factors, and you don't need to have them all, and no one weighs more than the other ones, but to be truly private, you have to discuss these type of factors. A court is going to have a high priority in not allowing something to be private, especially if we can see them as a place of a public accommodation, which has to guarantee the constitutional areas. A private club exemption. Is it genuinely selective? Generally selective means, does every person in this organization have a vote to allow new members in? If it has to be unanimous, it's very selective. It's 50%, 75%, 25%, it's not very selective. When we think of private clubs, think of the old country clubs in sport, Shoal Creek, Augusta National, things that are very exclusive. Member control over operations. Do you run everything, including the catering and the banquet halls and the facilities? History of the organization. Has this country club, has this organization been in existence for a very long time? If it's new, it's going to be looked at less by the court to be said it's a private club. Use of facility by non-members. Can an outside member rent the banquet hall for a wedding? Can non-members play on the golf course? How many guest passes do the members get? With a high priority of making it non-private, you look at these different facts and see how exclusive it really is. The purpose of the club. Do they advertise for membership? If I advertise for members, I'm not being very exclusive. Is it profit or non-profit? What type of formalities have been in association? We look at all of these different factors in Lansdowne, and we can begin to see, is it private or not? The Slidell Youth Football Association from the early 70s tried this idea of being a private organization, thus being discriminatory of who can play and who can't play. And we look at Thornton versus Shaker Heights Country Club. Again, a case that deals with a private country club. Is it private? Is it not? Can they set their own rules or can't they? Do they have to follow constitutional claims? So we look at this chapter in this section, and we look at a number of different areas. One, we look at the drug testing being a Fourth Amendment discussion, reasonable searches and seizures, and certainly the Vernoni case and the Earls case flesh that out of what we can do and what we can't do. And then at the tail end of this, we looked at if we have a private club that may not be allowed or responsible or required to follow complete constitutional aspects, how do we define that? The NCAA isn't really a private organization as defined by Lansdowne. However, it's not a state actor, so it doesn't have to guarantee a lot of the constitutional rights. And what the NCAA has done, which is very good in their spot, they allow a lot of appeals to these different areas. They promote the rules and violations of what's going to happen, and they charge schools with violations, and they allow an appeal. Do they do it perfectly? That's something you can argue with. Is it the same as something in a court of law? Certainly not. Is it something more than what they used to? Yes. So we look at this idea of constitutional issues with search and seizure and voluntary associations and right to privacy, and we see where the courts are going and kind of this tension between state actors and private actors.